Welcome, everyone. If you haven't attended one of these yet, my name is Alex Wilson, broker owner of Remax Wealth Builders Real Estate. I've been selling real estate for 11 years now. Also been investing in real estate for a significant amount of time as well. So my portfolio, I have a triplex in High Park. I also have 14 condos, investment condos, an apartment building in Hamilton. So I have a wide range of different properties. So we've had significant experience in what to expect during these times with dealing with different tenants and all the different asset types, as well as we went through April 1st. Luckily, all my tenants paid on time for my properties wise as well. I own a property management company, and I would say probably about 95% everything was okay. About 5% we had some issues with, but we were able to collect the rent from, I think we're at all our properties now. Maybe there's just one outstanding still that we manage. So we've had a lot of experience in April on how to deal with COVID and dealing with tenants and everything like that. So that's why we have the webinar. And to my left, I have Kyle Dovigi, Director of Operations for Remax Wealth Builders Real Estate, also a salesperson and a real estate investor. And our guest of honor, Elaine Page, an award-winning paralegal, recognized by the Ontario Law Society as Paralegal of the Year in 2013, an expert, 25 plus years in the business-wise, and she's going to be giving us her opinion on everything that's going on and how to handle things, and definitely some different topics that we're going to be discussing today. Now, I know Elaine wanted to bring something up right off the top about last week's webinar,
Right.
just some terminology that was used and everything. So I'm going to give the floor to Elaine right now.
Thank you, and hello, everybody. I hope everyone is well. On last week's webinar, I used, inadvertently, I used a word that was inappropriate to describe a group of people. I'm not going to say the word or dwell on it. I just want to say that I'm very sorry that I used that word, and I hope I didn't insult or hurt anyone, and I certainly didn't have the intention to do so. So I just wanted to clear that up. Thank you.
Now, Elaine, why don't we just jump into it, and why don't you define what a paralegal is?
Great, thank you. A paralegal is a legal service provider licensed with the Law Society of Ontario. We have been licensed since 2008, although many of us have been practicing long before that. And we are authorized to provide certain legal services such as tribunal work, small claims court, certain provincial offenses matters, and a long list of other things. And just as the same way as lawyers, we're accountable to the Law Society and Code of Conducts and all of those wonderful things. And there's about, I don't have the latest numbers, but there's about 10,000 of us across Ontario. And we are the only place in the world that actually has licensed paralegals who appear in court and are advocates for people.
And it's great because here in Ontario-wise, if you had some sort of matter on the residential tenancy side, you really aren't going to go to your lawyer for that. It's really paralegals that do all the heavy lifting, deal with the landlord and tenant board. So it's your paralegal that has the experience and has been on the ground dealing with these matters, both on the landlord and on the tenant side.
Yes, both actually. You know, the tenants have, as well as having the use of a paralegal or a lawyer, there is duty counsel. When we get to a board matter, there is duty counsel available for them free of charge. And there's also legal clinics. And so if that will deal with landlord and tenant issues on behalf of tenants. So it's actually a great time if you are a tenant and you are having some kind of legal issue, there are certainly places that you can go to and get help free of charge.
Now, in regards to, there's a few topics that you wanted to start off with. Why don't we, because they're fresh, they're new. So why don't we start off on those topics-wise that you want to discuss off the top, and then for everyone we can get into to dealing with how you deal with tenants if they haven't paid and those kind of things.
Right. And some of that will overlap. So really what I want to talk about is we're now into a month or so in terms of rents around this. And, you know, many of you have received your rents and some of you have not. And I want to acknowledge that it is an extraordinarily stressful time for everybody across the board, no matter whether you're a landlord or no matter whether you're a tenant. And I don't profess to be a medical professional, but common sense dictates where you have, on either side of the table, people who have mental health issues. Stress exacerbates and amplifies mental health issues. So what we've been seeing what I've personally been seeing in the last week is the escalation of mental health issues on both sides of the table. Primarily what I'm seeing, and it's only because of the nature of my work, I'm getting stories and concerns by landlords because of tenants who have whose mental health issues are flaring. And I really want to address that because under the Human Rights Code, we have the duty, all of us, the duty to accommodate people's health issues. And often it can be frustrating when you have somebody who's ill, whether it be physically or mentally ill, and because of their personal situation, they're unable to do as you wish them to be able to do, and we tend to get frustrated about stuff like that. So the real message is compassion here, and understand that whoever you're dealing with, whatever side of the table they may be sitting on, you don't know what's going on in their life. You don't know whether they have a sick loved ones, maybe they're sick themselves, maybe they suffer from anxiety. I mean, there's a whole host of issues that could be going on in someone's personal life that are really now front and center because of what's going on. Before we started, I was telling my co-host that I have a friend whose mother is 94 years old and sick in a hospital, and her daughter can't visit her. Like, can you imagine the stress that she's feeling? So we all need to take a breath, and I've been preaching for the last month about working with people, but now we're seeing what's happening when people aren't working with each other. And some of these situations are needlessly escalating. So my big message for everyone today is patience. And we'll work through this together, we'll come out stronger, and you will have a better relationship with your tenants if you exercise patience and kindness. So that's my big message. I could give you stories about some of the things I've seen. I'm not going to do that because I tend to get in trouble when I tell stories. Suffice to say, there's been some really serious mental health crisis going on in certain units. And the best way to deal with that is to get in contact with your tenants. Worker, if you know them, and if on the lease agreement you have permission to get in touch with a family member, then get in touch with them. But don't come down heavy with a hammer, because it's not gonna end well for anybody if you do that. So that's the first thing I wanted to talk about.
Yeah, no, go ahead, continue.
So the other thing that's been happening for me is I'm getting, a lot of landlords calling, and they are trying to backdoor evictions. They're in a situation where their money's running out, they're in panic, and they're trying to come up with all sorts of ways to get around getting the tenant out. In normal times, this is acceptable, and in these times, it's beyond unacceptable. You're dealing with people's housing. It's a very personal thing. The truth is, no matter how smart you are and how good you are at concocting a whole backstory around why you need the unit for yourself, most of the time, if it's all of a sudden, those stories aren't believable. So if you genuinely require the premises for your own use, that's one thing. But if you're just concocting stories in order to try to move forward on an eviction, you're going to find yourself in a very bad position down the line. So I'm cautioning about that. The other thing that I've been seeing is where landlords have gone ahead and done N4. So those are the notices of termination for non-payment of rent. The tenants have rights, and sometimes we forget that tenants have a lot of rights, and so they have the time now to actually research their rights, and they're discovering flaws in lease agreements. And so these N4s are all backfiring because tenants suddenly realize there's a problem. So I'm going to just highlight.
I'm sorry I'm laughing. This is the one comment that was made. They say the Prime Minister said that due to COVID-19 not to pay rent. I'm sorry.
Yeah.
Continue on, Elaine.
Right. So I'm going to just give you a couple, and these are maybe a surprise to some of you. These are not new pieces of the Residential Tenancies Act. They rarely get used, but now that we're in this situation and people are needing to defend themselves, they are getting used. So Section 4 of the Act is the first thing, which is a provision in a tenancy agreement that is inconsistent with the Act is not binding. So where does that play out? That plays out in all of those clauses that say the tenant is responsible for the first insert dollar figure, let's call it $100 on a maintenance issue. That's not lawful and it's not legally binding. There are other, there's no pets clauses. 99% of those are not binding. The one that people really often get surprised about is, especially in a house situation, that the exterior maintenance, snow shoveling and lawn care, it's in the lease agreement that it's the tenant's responsibility. And according to the Act, no, it's not. And the landlord cannot waive his or her responsibility. So we're getting people saying, okay, I owe you rent, but I've been doing lawn maintenance for 4 years and you owe me money for that. And then we get into this messiness. So that's one. And one of the biggest ones is under Section 12, which basically says that any lease agreement after June 17th, 98 shall set out the legal name and address of the landlord to be used for the purposes of giving notices. And often people are using the AREA lease agreements and they're not providing the tenant with the address for service. Guess what? If you don't provide the tenant with your lawful address of service, the rent payments are suspended until such time as you do, which is shocking to some people, and I get that. So let's say you're using one of those old forms and then you do an N4 for non-payment of rent. It's completely useless because the tenant's response is, I didn't have their name and the landlord's name and address, so I don't have to pay rent. So this is a good opportunity to be reviewing some of your lease agreements because some of them are really a problem. The other one is that in I don't have the date, but not that long ago, the Ontario government put together a standardized lease agreement. And that is to be used in each and every residential tenancy lease from that day forward. So once again, if you haven't done that, then you're in violation of the Act, and the tenant does not have to pay rent until such time as you do that. So I've got these lease agreements coming in that are all flawed, and then they're saying, serve N4, Elaine, serve N4, and I'm saying, you got a problem. I can serve it, but it's not going to get you too far because you haven't complied with the Act. So my big message is to really, before you start getting aggressive with a tenant, and I don't think you should be getting aggressive with any tenant at this point, you should ensure that your ducks are lined up, that you have the proper clauses in your lease agreement, that you're using the right form, that the tenant has your name and address for service. And if you don't have those things, now that you're all sitting around, trying to figure out what to do with your time, it's a good time to put those things in place, to craft them and send them to the tenant and say, here it is, please sign it. And you keep the terms the same. You keep, if the agreement started on Jan 1, you don't change those terms, but you formalize it in its proper form.
Now, question here. So let's say in a Schedule A, you had a no pets clause, which I know isn't applicable, but you had it in there. Does that mean I can't serve an N4 to them?
An N4 is for non-payment of rent.
Yep. Mm-hmm.
No pets clauses it's a separate thing. It would apply if you said, Elaine, you can't have a pet in the townhouse you're renting, and I brought my dog in, then then we'd be dealing with that.
So basically, it's only the address for service in the standard lease, which someone could then say, oh, I haven't received those, so I legally don't have to give you rent until you provide those to me.
That's correct. And then the other thing that we're seeing that goes right along with that is that there has been a failure to maintain the units. So the tenants are then they see the N4, and then they're bringing an application with a host of repair issues that you may or may not have known about. And now we're in front of the board on a tenant application. Mm-hmm. So this is part of the reason that I'm saying everybody take a breath, because if you fire a cannon, there's going to be a cannon that gets fired back to you. So dialogue is much better than cannons.
Yeah, and that's what we've been saying in all of these calls, and that's some great clarification there on those items. And so basically to let people know on the call, and we've said this in the past calls, the Landlord or Tenant Board has currently suspended evictions and evictions notices. What I mean, so any eviction that was previously agreed to, or any eviction that you want to apply for non-payment of rent, those don't exist. Also, the owner occupying, so the N12, so if you want to owner occupy it again, they are not enforcing any of those evictions either. So this is it. Again, what Elaine's saying in normal times, the stuff that she says in normal times applies. Now we're under a magnifying glass. So dialogue is so important, having the communication with the tenant wise. So let's open that up now. So what it comes down to is it's stressful on both ends. It's stressful for you as a landlord because you have costs. You have your mortgage, you have your maintenance fee, you have your property tax. The tenant's stressed because they may or may not have revenue coming in. And it's an unknown for you if they're being truthful on the other end. And sometimes that's always great to bring in a professional. If you don't know what questions to ask, Elaine knows what questions to ask to help her based on her experience wise, if the tenant is being truthful in regard to what they're disclosing for you. So one easy thing to ask.
I'm going to just stop you right there. I also know when my, potential, I don't always know, but I have a good sense that when my potential clients are calling me and telling me a story, whether they're all telling the truth to me as well.
Yeah,
so
exactly.
It works both ways.
Exactly, yes. Especially when, let's say, for example, you're dealing with Elaine or you're dealing with your real estate professional, just be honest. And here's why it's so important. I'm not judging you. Elaine's not judging you.
Right.
But if we don't have all the facts, we can't help you. If there's a landmine we don't know about, it's going to blow up down the road. So just disclose everything. Because if all the facts are out there, then a path can be charted to navigate the waters wise to get to the desired end result, if that end result is still achievable. Or maybe you just need a frank response going, that's your desired result. That's not going to happen. But here's things we can do to mitigate some of the losses associated with that. And the sooner we do that, everyone can move on with the rest of their lives. So, Elaine is great for that service and everything. And I always like to tell my own personal story. How I know Elaine is I had to use her for my own services. And I'm a real estate agent. And the house that I bought, that I live in currently, we bought a triplex. Part of the portfolio when I describe it to people. There were 3 leases in place. 2 of the leases were binding leases. So what I mean with that is that they were signed into 1-year leases and they're during their 1-year lease term. So any property you buy, you get all the properties, the properties stay with it, the leases stay with the property. The lower level tenant, that was month to month. So I could provide the seller was to provide the 60 days notice to the lower level tenant that the buyers were moving into it, which we were moving into it. Now, this is where it's so important that the forms are filled out correctly. The seller did not fill out the forms correctly. I don't even know if the forms were issued correctly, but anyways, there were issues with the forms. And when it came to closing wise, the tenant had not left the property. Their claim was things weren't filled out correctly wise. And lo and behold, I, a real estate agent, was homeless. I tell my wife we were homeless, and we reached out to our lawyer. Our lawyer said, call Elaine. So again, the lawyers typically aren't dealing with this. You called Elaine, and Elaine told us it could take up to October because the whole process had to be restarted wise. But she was able to bring it down to probably about 3 or 4 weeks, and we were able to move into the house wise. And it was all just things weren't filled out correctly wise. So it's so important for these things to be filled out correctly, but also it took the burden off me, and the hands were in the professional. Our stress level was here. Our stress level went down to here. We knew what the answers were. We knew that we had someone working on it for us, and we knew we were able to move forward. So a lot of the time, it's just stop stressing about it yourself. Just call someone else to deal with it wise. Write the check and move on. And Elaine's services are fully a write-off on the rental income coming in. And if there's no rental income coming in, well, guess what? Elaine can probably make the situation that rental income will start coming in sooner than if you wait a few months and try to deal with it. So that's where dialogue and everything is so important wise. And again, going back and working with the tenant. Now, continue on that, talking about working with the tenant wise. And I know Elaine and I had conversations about this last week a little bit. Tenants for the most part are reasonable. And if there are some sort of issues on payment wise, maybe they are only going to pay part of the rent for a certain amount of time. Why don't we get into rent deferrals? Language, rent deferrals versus rent reductions. We're not even going to talk about rent reductions because none of your costs are reduced. So never use the word reduction. Rent deferral means that a portion or all of the rent will be paid at some point in the future wise. So let's talk about rent deferral.
Sure. So rent deferral, a lot of people get the terminology incorrect. So we hear the word rent abatement. So just to distinguish that, rent abatement is when you give the tenant back some money because of something. So for example, the furnace broke for 4 days in the middle of the winter. You might consider giving, and they had to go to a hotel or they suffered in some way, you might consider giving them an abatement. So here is some money to compensate you, or the board might issue an abatement. So that is different than a deferral. Deferral really speaks to sometime in the future that you still owe this money, but sometime in the future you have to pay this money. So we do that by initiating dialogue with the tenant. And I'm going to give you some language because it's language that I use and I'm happy to share it. And it goes to what I said at the beginning of this around kinder and gentler. When your tenant gets a phone call, and please don't do this over text because people often misinterpret what the tone of a text. They get a phone call and they look on their call display and they go, oh my God, my landlord's calling me. And if they're not in a position where they can pay, their anxiety level, escalates, and maybe they'll answer, maybe they'll dodge you. So let's go with the assumption that they answer you. The first thing you should say is, how are you? How are you coping? How you doing? You okay? Everybody well? And the reason that I tell you to do that is, and to be genuine. If you can't be genuine about it, don't do it. But at the end of the day, we're all people, and we're all, as I keep saying, we're all under stress. But that kind of reach out on a human level it diffuses what they're expecting, which is, you screaming and ranting and raving, where's your rent? It diffuses it so that it allows you to actually have a real conversation. And, you communicate with them and find out what's going on, because maybe nothing's going on. Maybe everything's great and they're working and they forgot, or whatever their story is, we don't know. But maybe there's a real critical problem going on there. And you need to know that, because the only way to get to achieve the goal, which is to have your rents paid at some point and have a tenant who is safe and well in their home, is to be communicating. So remember, they are people, and treat them with respect and dignity. And I think what you'll find is how much they appreciate that, and how much more they are willing to work with you if you treat them with respect and dignity versus yelling and screaming. So that's the first thing. So that should be your tone. Not everybody's able to do that. Some are just highly emotional, and that's when you need a third party to come in and do that for you, because you're not, that just makes sense. Oh, sorry, excuse me. So have the conversation, and depends, every situation is different. If you've had a tenant who has been there for 5 years, never had a problem, but now because of what's going on, they have a problem with money, then that gets treated very differently than somebody who's been living in the unit for 6 months prior to COVID, and every month for the past 6 months they've been late with their rent. So assess your situation. In the case of a 5-year tenant, I'm not sure that I would send them an N4. Depends on what their industry is, and whether it's likely they're going to be able to get back to work, or whether they've applied for some of the benefits. With the ones who are relatively new tenants who have a history of late payment or non-payment, I would absolutely be moving forward on those ones. Doesn't mean you can't make a deal with them. It means that's your little insurance policy, that if they promise that they're going to give you a chunk of rent in a week's time and they don't, you can move forward. And you want to always be able to move forward, hopefully in a positive way, but you want to protect your rights and move forward.
Yeah, and I'll bring up Kyle in this situation. Kyle, in one of his units, he has a bartender that lives in one of his units. Been a great tenant. Been in there for 4 years now, and obviously she reached out to him in March. He wasn't surprised. He was expecting the call, because he knows her employment is not operating right now, and she did pay April rent, and he had the dialogue with her and showed empathy. And again, empathy and weakness are two different things. That's what's key. And that's where, again, if you're not comfortable having that conversation or stick handling those kind of things, there are third parties that can reach out, again, Elaine, on this call wise. But yeah, empathy is important wise, because as soon as you get your back up, then the tenant's going to get their back up. So you can either choose to go to war, and if you go to war, then you're not getting any money, right? Or if you take the empathetic approach and have a conversation, but again, empathy and weakness, two different things. Be empathetic, but maintain a strength as well. You're not going to give them the farm either. So there is a balancing act that you have to take, and some people have that skill, some people don't. But it's important to, if you go hard right at the beginning, you just shut the door. And that's where things can definitely start going sideways.
And we've got a couple questions.
Yeah, should we go right into the questions now?
Right now, just on this topic of payment of rent, does it make a difference if your tenant hasn't paid all of the rent or just a portion of the rent?
Well, yes and no. So let's just arbitrarily set up a number of the rent is $2,000. And the tenant's got the served, so they're able to pay $1,000. There's $1,000 outstanding. That outstanding amount at some point will have to be paid.
So they legally owe it still, correct?
They still legally owe it. It's not forgiven. It's as Alex said, it's deferred. It's not forgiven.
And that's where and we've used this example previously, Elaine started on it. So rent's 2,000, they give you 1,000, you come to agreement in place going, okay, I know things are tough right now. I know what your situation is, because if you put the person in, you know what they did as a job wise, and you're like, yeah, probably you've been impacted with that. So it's Kyle dealt with that situation. Okay, for 3 months, we'll reduce the rent by this, but then we'll set up a payment plan after the fact, or once you're back on your feet, you're going to have to pay that back. Now, one of the things that you can ask for, now to clarify, the tenant doesn't have to provide this to you. You can ask anything of the tenant. Tenant may not provide you with anything, but if you ask questions, and if they know they're not being truthful, I would say 95% of the people, if they know they're not being truthful and you start asking questions, they're going to start backing down. So if you ask for a record of employment to show that they've truly been laid off wise, because that's what if you've been laid off, you get a record of employment. You can ask for that to just, okay, prove to me that you've been laid off. And when you start asking those questions wise, the people that are taking advantage of the situation, they're gonna disappear quickly. Now there is 5% of the population which, they are going to take advantage of the situation, and they are going to lie to you, and you don't know what to do, and that's sometimes when it's best again to bring in a professional. I noticed just in the chat here, whose name was this here, but they seem to have quite the situation. Okay, there it is right there. I think it is it was Akash. So Akash, he has a tenant that hasn't paid rent since February, and this is before COVID came in, and he's obviously not paying rent now. So that's a serious situation right now. And his concern is May 1st is coming. He's like, I know I'm not going to get a rent. What can I do? Well, I'm going to say he's in a pretty tough spot, because he's very limited in regards to his choices that he can do right now. So why don't we just talk about that quickly? So I have a problem tenant, and I have no landlord and tenant board right now.
So that's a great example. So I've talked about this before, and I won't go into lengthy detail about it, but prior to COVID, there was a huge problem at the landlord and tenant board with backlog. So we were waiting months and months and months to get hearings, where conversely in the past, it would take us a month and a half to get a hearing, depending on the location. So I don't actually foresee that changing, because I haven't hired any new adjudicators. But when we have tenants who prior to COVID were in arrears and now continue to be in arrears, that's when you really need to be looking at getting the notice done. Now, the notice is a 15-day notice that gives a tenant 15 days to pay all of the rent, after which time you can apply to the board. So you can apply to the board via e-file. You will not get a hearing date, because they're not giving out hearing dates, but at least you're in the queue, so that when the things get back to normal.
Oh, we lost Elaine.
Oh no.
That at least you're in the queue. If you wait, sorry.
Yeah, your video has stopped.
Hi, can you hear me?
Yeah, we can hear you. Yeah.
Yeah, it looks good now.
You're okay now, Elaine.
Okay.
Yep.
So I'm recommending you get into the queue, because it's going to be a very long time, and I don't know the dates. Nobody does, when the board will be back up and running, but it's not going to be in the next, week. So you need to get in the queue. You need to start the process. There are no evictions.
And to clarify that, this is so important for you to do it right again, because if you start the process now and you get I'm going to use again Akash's specific situation. You have a problem. If the tenant hasn't paid you rent in February, you're not getting rent now, you have a problem tenant. You need to get your forms in right away, so when they open back up, you are going to end up in a hearing and dealing with different situations. That's just the light of where you're going to be, looking at the situation now. So it is so important that all your forms are correctly done, because the last thing you want to do is, okay, we put our stuff in, now we finally get our hearing date, and we get to the hearing and they're like, nope, forms are incorrect, start the process over again. And again, you'll be another 3 months at least before you get back to that process wise. So you got to make sure your forms are filled correctly. So I know that you're looking for an answer on what can I do now. There isn't anything you can do.
Other than an N4.
Other than the N4, yes. There's nothing you can do to force that tenant to give you money right now. And I know it's probably burning you up inside. I know how angry you are because you're like, show me my money. This is my property. There's nothing you can do right now, unfortunately.
Right. And Alex, if I can just jump in, one of the things that I've been seeing a lot over the course of the last couple of weeks are landlords who are doing N4s. And so let's just, for argument's sake, say January's rent is unpaid, and so they do an N4, and then February comes rolling around, January is still unpaid, they do a second N4 for February's rent. When you, and March, they may do the same thing. So now in March, they've got just either March's rent, or they're going back and doing January, February, March, all on the same N4. If you do that, then you try to file an application, chances are it will get thrown out. So what people don't realize is if I were serving an N4 today, it would be up in May, and I have to calculate it, but let's call it May the 12th or so. And it actually includes May's rent. So on May 12th, if the April's rent wasn't paid and now May's rent isn't paid, that is the time that you start an application. You don't do another N4. So you're shooting yourself in the foot if you are just sending N4s for every month that the rent isn't being paid.
Now I have a great question here, and it was something that was in the back of my mind, and I just saw it come up. And you can correct me because I have a thought in my head that this would rectify it, and many times you've corrected me and I've been wrong. So Maria asked, should I bring out a lease is 6 years old and update it with my address on it? Couldn't I just send an email to the tenant going, hey, this is my address or service, please acknowledge you received this?
Yeah, that's perfectly fine.
Okay, perfect. Yeah, so you don't need to update the lease, just send them an email and just going, here's my address for service-wise, please acknowledge. That's all you need. Yep. There you go. Yeah, I'm glad we could help you, Akesha. I'm sorry it wasn't better news and that kind of thing. And I for you specifically, you definitely need to reach out to Elaine directly wise and help you with that process because you definitely have a problem. And here's the good news. You own the asset. It's still going to go up in value wise. You're just in a short-term situation right now. It will rectify itself some point in the future. So that's the good news. Short-term, no good news. Long-term, you're still going to win. And I think let's open up the whole question. So Kyle, do you want to get into these? It's nice to see it's not 117, it's just 17. So
I know, great. Yeah, it's a handful this time. So Anita asks, hi guys, nice to be back. Hope you're well. Quick question. I have 2 persons signed on a lease. Can I remove one person of the lease and have them leave if the landlord is okay with this? Do I need the person whom we want to remove have to give us consent, or can we just do that?
Yeah, no, if you're taking somebody off a lease agreement, you need to actually have consent of both tenants.
Great.
Yeah, I would say, yeah, all parties have to be agreed to on that.
Great, thank you. Amy asks, one of my tenants are leaving for a new job, but they've told me that they're not going to pay June rent, assuming that's the last month's rent. Can I keep their security deposit and call it even?
No, I'm not. If they're breaking the lease, is that the situation? Because I didn't read it. They're breaking the lease?
It doesn't say.
Well, the last month's rent deposit gets used for the last month of the tenancy unless you've made an agreement under COVID to use it for April's rent. Beyond the last month's rent deposit, there should not be a security deposit because security deposits are not lawful. So if you have a security deposit that is beyond last month's rent, you should be returning it.
Yeah, I think I'm going to give a scenario, and I think this could be the scenario-wise because we come across it a lot on our end. Let's say we're 6 months into a lease-wise, and the tenant says, "Okay, I'm leaving," and hasn't lived up to the end of their term-wise. So what we typically do is we say, "Okay, that's no problem. We'll remarket the property for rent-wise, but you're going to be responsible for the cost of re-renting the unit wise. And then typically that's the last month of rent. I think that's the situation that Amy's probably going. So basically what it is, they're responsible for May and June, and then we're using June's rent if they're prematurely left the property, or they're prematurely leaving the property, and we're using that to compensation wise to get the unit released. Ultimately what it is though, Amy, is that if the tenant's not going to pay you, the tenant's not going to pay you, right, Elaine?
Pretty much. Yeah. And it's an interesting question because there's case law on this subject, and there's some sections of the act that deal with it. And it used to be that we would sue people for the remaining portions of a lease agreement, and we pretty much can't do that now because of some changes to the act. And one of the things I'm going to say to you, I mean, I don't know if your situation is today, but I know that the act is being amended, and the process of the amendment started in the first reading of the bill happened right before COVID, and I anticipate that as soon as things come back to normal, that this will be made into law in some form. So the answer today may be different than the answer in 3 months' time, but the new amendments to the act deal with this type of situation.
Yeah, and Amy, I'll go back to that. I basically dialogue is what you're going to have. So what I would say is go back to them and going, okay, if you're assuming they're prematurely leaving the lease, if you're prematurely ending the lease wise, then that last month is going to be going towards the renting of the unit wise. That's assuming if that's the case wise.
But in general, you are able to use the last month's rent, correct, Elaine?
Yes.
If it hasn't paid, just want to make sure it's documented and you're telling them what has occurred, correct?
Right. Yes. And then you can't go back later and say it's arrears. If you've agreed to use the last month's rent deposit, like this is untested territory, to be honest with you, like because of the situation we're presently in, but you can't use it, agree to use it, and then later on turn around and say, that you're in arrears because we're now putting the last month's rent deposit back into the deposit shelf and you're in a month in arrears.
Okay.
The second part to that question. So when a tenant moves out, typically a landlord does a final inspection. Who is eligible to do that inspection?
And the landlord or an authorized agent of the landlord, and that could be their real estate agent, it could be their property manager, it could be their son, their daughter. As long as they're authorized by the landlord to do the inspection, then they can do it.
And how do you authorize them, Elaine?
Well, I would put a note out to the tenant and say, hi, you know me, I'm your landlord, and I authorize Kyle to do the final inspection of your unit. Thank you very much. It's not complicated.
Great.
Okay, so do you want to do the next one?
Yeah, so Raj has a pretty detailed question, but one part of this struck me where his tenant is paying 80% within the first 3 days of a month, and then about a week later, he's paying the final amount, the 20% difference. Do you have any thoughts or concerns about this, Elaine?
Yeah. So under normal circumstances, that would be considered potentially persistent late payment of rent. There is an application available for that, which is a termination application, although I must admit I've never actually seen a tenancy be terminated for late payment. Typically, an adjudicator would order that the tenant pay the rent by the first of the month, and then if they don't, then there may be an eviction. At this point, if you're getting all of your rents by the 5th or 6th of the month, you're in great shape, and just say thank you.
Yeah. Okay.
Nice. So Flora asks, she has a tenant that just moved out, and obviously this is a challenging time to find a new tenant. What tips can you offer in terms of gauging the stability of the tenant or screening them in advance?
Oh, that's an hour-long webinar unto itself. There are some services out there as well. Property manage, it's a good time to hire a property manager because they're very well versed in doing all sorts of checks for you. It's part of their services. So I potentially recommend that. But one of the things for me that I always say is, so let me ask you this, Kyle, are you able, I have this great unit for you. It's beautiful, 4 bedrooms, swimming pool, fantastic. The rent is $3,000 or $2,000 a month, but the catch is you have to move tomorrow. Can you do that?
Obviously going to be very challenging.
Right. So most of us who, have some normalcy in our lives would not be able to just pick up and move in 2 days. And for me, when I see that happen, it's generally a red flag that there's something else going on. Now, sometimes it's a case of partners breaking up and one needs to get out of the house. But if it's a family, they may be in the process of being evicted from somewhere else that we don't know. So it's a red flag, and I would question that. That's number one. The only other thing I'm going to tell you about this is references, and Alex will tell you this, they don't mean a whole hell of a lot. Because if I have been a problem, not me, but you've got a problem tenant who's dealing drugs or hasn't paid their rent for 8 months for no particularly good reason, they know that their landlord isn't going to give them a reference. So what they do is they have their pal's phone number on as reference, who will then say, yes, they're the greatest thing ever, never had a problem. So you don't put a lot of weight into references.
Yeah, I will give, basically, you do credit check, your own credit check, very important, your own credit check. And you do get an employment letter and validate the employment. If you do those things, you're pretty much okay. Truly what it is. So those are the best things that you can do.
Yeah, and I would also say, just on the credit check, be discerning on how you interpret it.
Of course, yeah.
Somebody may have had bad credit because of a life situation 5 years ago, but there's nothing new on the credit bureau now. Or somebody may have had a dispute with a credit card company, so it may be that there's a credit card debt on there. But if you're not seeing anything on the credit bureau around a previous landlord or series of landlords, then you're probably okay.
Yeah, and some people don't know how to read the credit report and everything like that. So yeah, there's different things to look into, and I've looked into it before and everything. So yeah, you got to look deep into it.
Great. So Anita has a question about the service address information. It looks like hers was not written on the original lease. So do you
just an email. Just an email.
Great. So Asim asks, what happens if your tenants are not on a lease and are just month to month? Does it have a huge effect, Elaine?
I don't even know. That's not even a question. Next.
Brenda asks, is there a government program to aid landlords who can't rent their property or condo?
Not in the residential world. In the commercial world, that there was something announced about in certain circumstances where small landlords 75%, but I don't know the details about that. But not in residential.
Raj, call Elaine.
Raj is having a difficult time getting a hold of his tenant.
Yeah, and Raj had said another question in regards to he was the 80%, 20%, and now he said he requested they pay whatever the government's paying. They built a brick wall. Time to reach out to Elaine.
So I think Dixon faces a situation that many landlords face, where how do you handle a situation where a tenant has brought in a pet sometime after moving in, even though in their agreement there's been a note that pets are allowed on the premises?
Well, hang on. It depends. It's not quite nothing. Generally, no 90%. Pets clauses are void. It depends on the pet, number one. Like if it's, I'm not kidding when I tell you, if it is a inherently dangerous pet, such as a kitten that is really a lion kitten, and this has happened. That's one thing, but a dog or a cat is not an issue unless, and this has happened for one of my clients. She left, she went away for a year, rented out her house, and she has an anaphylactic allergy to pet dander and somebody came in with an animal. And in that case, we can deal with it, but you can't just say I have an allergy. You actually have to have a verifiable anaphylactic, an allergy that could kill you. But generally, no pet clauses are not valid.
The only other instance is there are condo buildings in Toronto in the bylaws that state there are no pets allowed. I can name the buildings: 30 University, any of the Harbor Square buildings. No pets are allowed in those buildings. In those cases, if there was a pet in there, there's recourse for that. So
right, but, and this is where the but comes in. You as landlords and you as real estate agents should ensure that you give a copy of the bylaws to your tenant, because their response is going to be, I didn't know. There's no, I didn't have an opportunity to review the bylaws. I mean, you're going to hand it to them. They're not going to read it anyway, but at least you have them sign off that they've got them. And then if this issue comes up, then you've got something to hang your hat on.
Okay.
So the next question is, how can a landlord actually collect rent, deferred payments if someone moves out?
Well, hopefully you've started the process with the N4, and if you get an application issued before they move out, then that application is alive and well, and it means you're going to get an order for money, not for eviction, because they're already gone. If they've already left, the recourse is the small claims court, sort of, and we talked at length. There's a case in there that says maybe it's not. It's a gray area of law at the moment, which we're hoping in the near future will be clarified.
Great. Alex, did you see any there that you wanted to?
Yeah, I'm into Sasha now. So what happens if the landlord is bullied and threatened by the tenant, a short-term rental company? If there was an inquiry about missed rent and this escalates if rent deferral and reductions were offered by the landlord. Okay, so we talked about this last week, Sasha. For the short-term rental companies, those end up actually being commercial leases. And Elaine, in the chat box, do you want to put the lawyer that handles the short-term leases in there?
I will send it to you after, because I don't have his number
Yeah,
in front of me.
So Sasha, we'll send you the for the short-term leases wise, the best person to reach out, because it ends up being the commercial side, and we have a specific lawyer that handles the short-term lease situations, the Airbnb. So what it is there are a lot of companies out there that lease units wise, and then they manage the units and then release them out using services like Airbnb and everything like that. Those end up being beyond the landlord and tenant board. Okay.
So Lindy asks, if they've agreed to use the last month's rent for April's rent and they make a partial payment for May, would you include April's rent on the N4 when you serve the notice in May?
Well, that's exactly what I was just talking about a moment ago. No, if you've got it in writing that you've agreed to let them use that month's rent for April, then you can't then turn around and say, pay it back now.
So here, this is a great question here, and I offered a lease extension for 6 months due to COVID-19. Since their lease came up at the end of April, can I not extend the lease after 6 months if they're not willing to renew for another year? Since I prefer a yearly lease instead of 6 months lease, what are your suggestions? Here's the thing. No, you can't do anything. So what it is that once the 1 year lease is done, then you go into a month-to-month situation, and that lasts in perpetuity until the landlord gives you the tenant gives you 60 days notice that they're leaving, or if there's some other, in case you're moving in or something like that. So it may be a preference to have year leases, but the tenant doesn't have to agree, and the tenant's rights supersede your right on that. So that I like that question, because a lot of people are they have in their head, oh, I'm going to renew my tenant for 1 more year. That's just not the case. You don't need that. You don't need to renew them for 1 year. I tell landlords, don't renew for 1 year. Allow the flexibility because things come up. Would you agree, Elaine?
100%.
Yeah.
A lot of the applications, like let's say you decide you want to sell the unit and the purchaser wants the unit for themselves. You can serve that notice, but it's what we call an end of term notice. So if you've now renewed for a year, their notice of termination will be at the end of that year, maybe 11 months later, and now you're stuck because you can't really sell your unit.
Correct. Yeah. So you want to maintain that flexibility, and again, there's nothing you can do on that. The tenant doesn't have to agree to anything. My tenant was able to pay April. They confirmed they will be able to pay May. I tried to set up a repayment plan for April, but he doesn't seem to be very cooperative. Do I still collect May rent and figure out April later on?
So the answer is we don't. Hang on. The answer is we don't actually know because we need way more details. But what I will tell you is, and tenants get confused by this all the time. If you receive your dollar amount that is equivalent to rent on May the 2nd, that actually gets applied to April's rent. They are in arrears for May. So you always take the money and apply it to the oldest arrears first.
Great. I'm going to summarize Carl's question here. And essentially, is it sometimes better to negotiate with a tenant versus going through the entire eviction process?
It's always better to negotiate with a tenant. So you're more likely going to get a better result if you negotiate and both sides are happy or reasonably happy. I will tell you that one of the things we do quite often is that we do issue the application and we go to mediation at the landlord and tenant board and we get things resolved through an impartial mediator.
Great. So Sandeep had a question about moving back into the unit. And this one's interesting because it sounds like he has a year lease and halfway through he needs to
can't do anything. Easy answer. Yep.
So Elaine, are you able now in this environment to move back into units, to evict tenants?
Well, if you own a unit and it is vacant, then you want to move into it, you're welcome to. But if you're talking about evicting a tenant to move in yourself, you can serve the notices if it's bona fide. If you really are moving back in, you can serve the notices. However, you will not receive an order from the landlord and tenant board evicting the tenant and giving you possession.
Okay. We've only people that can. Okay, great questions. We actually didn't talk about it this time, but we have in the past. Who can serve notices? The owner and someone that's licensed with a law society.
No, let's distinguish that.
Yep.
Who can serve notice? The service of a notice is me handing you a document and saying you've been served.
Yeah. Mm-hmm.
Signing notices is what you're talking about.
Yeah. So Ali, I'm glad that Elaine did that clarification. So the only people that can sign the notice is someone licensed with the law society, so a paralegal or a lawyer, or the owner. Now, very easy to do that. If you have a property management or real estate company that's helping you with that, they could just send you an electronic signature document for the owner to sign. So it's not hard to actually do that. But only the owner or Elaine for this case would be the signee. You want to jump in, Kyle?
Yeah, Peter had an interesting question. Whereas tenant has agreed to take care of maintenance, things like shoveling, snow removal, lawn. Mm-hmm. What's the best way to legally arrange that and protect yourself?
It's a tough question. I haven't tested this, and so I'm hesitant to say it because I don't know if it would work or not. But you could potentially have your lease agreement being $2,000 a month and have a separate agreement where you're hiring your tenant as your landscaper. Now, again, I haven't tested that, so I don't know if that would fly, but that would be pretty much the only circumstances that I could think might work.
So Ali just asked, even if I have a POA from the owner, a power of attorney, for the signature of the N4s.
If Ali has a POA, then Ali may sign, but they're Ali signing as POA for the owner. It should be identified.
Yes, you actually have to put POA, then your signature.
Which leads me to something that we've talked about, and briefly I will remind folks. POA means power of attorney. If you don't have one, you should. If you don't have a will, you should. Only lawyers can do them. Do not use the packages that are online because most of them are garbage. So this is a really important time to make sure that your affairs are in order. God forbid something should happen to you. It's your, your wishes need to be known.
So Amanda wants, yeah, give this one to Elaine. Give this one to Elaine. Yeah.
Yeah, she rented her unit to a short-term rental company as the tenant, and the tenant put it up on Airbnb legally to a guest. And now the guest in the unit is refusing to leave the unit. What rights do they have?
Commercial tenancy, I'm going to give you the name. This happens quite a bit. It's one of the reasons I don't like short-term rentals. I'm going to give you the name of a lawyer in the follow-up who really does a lot of this kind of stuff, and I'm going to let him advise you.
Yep. Okay, so tenant said they're basically someone named Webinar. Basically, tenant said they're leaving, but now they're not leaving. What can I do when the board opens again? Well, then it would just go back to normal, right?
Well, and it also depends on what I'm leaving. And off I go, or they've filled out the proper forms. If they haven't, if they've just said in a text message, I'm leaving, or just verbally told you I'm leaving, it means absolutely nothing.
Yeah, so the key is they've signed the forms and they filed the forms with the board, and then once the board opens back up, then it would be dealing with in that case, as long as everything was filled out correctly.
Right.
Okay.
So Tushar had an interesting question. Apparently there's some municipal government programs to rent your property to homeless people or financially insecure people. Is this a safe thing to do? And what happens when the government term is up and a client refuses to leave?
So I don't know specifically what programs we're referring to, but I will tell you that there are supportive housing organizations, and they have been around for quite a long time, that help and assist both homeless and people who may have health conditions. And they're essentially tenants. You can't just throw people out of their homes because you want to throw them out and you want the property back.
Can you suggest any specific clauses in regards to COVID-19 to put on a new lease agreement? Here's what it comes down to. The standard lease agreement is actually your lease agreement wise. So unless there are any changes to the standard lease agreement made by the government wise, any other specific clauses mean nothing. So you can put whatever you want words wise on the agreement. They're not enforceable unless they fall within the standard lease. The standard lease is your lease.
But there are some things that are not in the standard lease that you might want generally in a clause, things like insurance and such.
Yeah.
So I have a colleague, his name is Harry Fine. He has a forms package that has every imaginable clause that you can basically go in and cherry pick clauses that apply to your situation. And I would venture to say that if Harry has created the clause, they're lawful clauses. And that's Landlord Solutions is his company name. Oh no, that's not it actually. Just look up Harry Fine, F-I-N-E, Paralegal, and you'll get to his site.
Okay, 2 more questions. What can you do if your property manager has not done his or her due diligence and hadn't alerted the tenant they cannot change locks without notice and key copy, but blames the tenant but doesn't admit the mistake? What recourse does the landlord have concerning the property management? Ultimately, that is a business issue. Let's say I have a dispute with Canadian Tire or any other business relationship wise. So that's not a landlord property management RTA issue. That's a business issue wise, and you just gotta have a conversation with them and go, okay, I fire the property manager, go threaten them with that. How you deal with any other situation with a business wise if you have a dispute. That's my advice, right, Elaine?
I totally agree.
And then finally, last question. Hello, according to my tenant, the provincial government has put a freeze on rent increases. Is that correct?
Not that I'm aware of.
Now, here's my recommendation. We've talked about this before. It's not a time for you to be doing rent increases right now because you don't really want to give you a reason the tenant to leave. If you have a good tenant in there, they're paying wise, this is when you want that tenant to be staying there. Now, and I've said this to other people and people didn't know this. let's say I have a 1-year lease and the 1-year lease is up May 1st wise. And you're like, oh, do I have to wait a whole nother year to do my increases? No, all you need to do is give 90 days notice for your rental increase at the end of a rental period. You can do that once a year. So let's say right now is not a good time to give a rental increase. Well, maybe in 3 months it is. So then wait the appropriate amount of time and then give the notice why. So there is no freeze in regards to the rent increases. But I can tell you that market rents are below what rents were in 2019. So you're better off with the tenant in there versus not having the tenant in there. It's not the time to do rental increases. Unless it's grossly under market, then maybe you want to do a rental increase at this time. But you just have to give 90 days notice.
But it has to be the lawful rate.
Oh, yes, of course. So we'll go into that quickly wise. Anything built before November 16, 2018, you're under rent control and whatever the lawful rate the provincial government prescribes. I won't say the exact number right now because I don't have it in front of me. It was something, I said I wasn't going to say it. It's online. Number 2, if it's built after November 16, 2018, there is no rent control. So you could issue as much as you want for a rental increase wise. But again, if it goes empty, you're subject to market rent. So that's ultimately that. And as everyone knows, or if they don't know, this full thing has been recorded. You will be emailed a recap sometime today or tomorrow wise of the whole video recording. And it'll also be pasted on our YouTube channel as well. Elaine, thank you so much for giving your time today. We really, really appreciate it. And that was a nice amount of questions versus 117 we usually get. So it was nice to get all through those and deal with that. So thank you so much for attending. Elaine's details will be going out as well. So I know Raj and Akash, you guys are running into a lot of issues. I would 100% recommend reaching out to Elaine wise for her services because I'd say you're at a brick wall right now. Okay. And Kyle, thank you so much for moderating wise. If you need any investment advice, please reach out to Kyle. His information will be in the email as well, and we'll talk soon. Okay, guys. Bye-bye.
Thanks, everyone.
Bye, everyone.